Well, welcome everyone. Good morning. I can see everybody in the chat. Hey, very excited here to get our podcast rolling. Can everyone hear me okay? I can see you out there. Uh, Definitely welcome from El Paso. I see we have Highland Lakes team coming in, people from all over. We're very excited to present this update before it's mandatory on February 1. We love what we do here, selling land and farm and ranch. And it's very important that we know our forms. I am a stickler for it. I've been very blessed to have an amazing attorney, owner, friend, title company owner here with us today, and to go over these changes because they're coming quick and we need to have them under our belt. So without further ado, I'm going to take and introduce our speaker. This is Mr. John Dodson. He is a seventh generation Uvaldian from Uvalde County, Uvalde, Texas. So his roots run deep here in Texas. And then you can see on the board here on the slides, no end to the list of accolades for this gentleman. Welcome, John.
Oh, good morning. Good morning, everyone. Thank you, Lindsey. Thanks for inviting me to be here on your program. Look forward to getting into today's discussion and hopefully find it informative and worth everybody's time today. You and I've talked before at other forums, and hopefully we've gotten pretty good feedback out of it. But I'm pretty much a rookie at this, so y'all bear with me as we go through it today. But I look forward to presenting what I know. You see there that Lindsey's kind of put up a little bio real quick. I had the opportunity to buy Garner Abstract, which has been in business since 1891. Bought it in 2015. And we've got quite an extensive plant, many base files. So it was very, very good purchase for us. I've since learned the ins and outs of TDI and the insurance business. So I brought a lot of title experience on the legal side and the contract side, but I've had to learn the hard way the insurance side. So it's been quite a great 5, 6, 7 years now, going on 8 that we've owned it. We've since during that time, as you see at the bottom, we also have Rancher's Title. That's just another brand that we own, same company, same staff. We did that in order to try to have a broader statewide reach. In 2021, I believe we closed files in 76 different counties throughout the state of Texas. So we did that in order to try to obviously expand our market share, but also to give people like you all a place to go, consistent service with a consistent team that understands farm and ranch transactions. There's just not a whole lot of residential transactions in Uvalde compared to the bigger counties. And so we thought we'd leverage our experience and knowledge in that area. And it's worked out really well so far. We've developed a great relationship with Lindsey and her team, as well as other brokerages throughout the state of Texas. And we have contacts in a lot of these smaller counties that are owned by that attorney that owns the title company. And we work well with them in order to get that title work out of them as quickly as possible. And then we service the deal from there going forward. So we've enjoyed it. And we're looking forward to expand our opportunities throughout the state. Lindsey's popped up there. Why hire an attorney? I'll try to keep that brief.
Well, in residential, there's really not a lot of moving parts. It's straightforward. Most of the time, they don't feel the need. There's not a cloud in the title. It's just it is what it is. 3-bedroom, 2-bath. Everything came out okay. No clouds in the title. So, in farm and ranch, obviously that's a little different, as you very well know.
Absolutely. So that residential, as you said, it's more of a cookie cutter, for lack of a better term. It's repeatable. It's pretty standard, and that's why you see we're seeing the push to go to even try to blockchain the title work so that you can just repeat it. and have everything, and which I don't understand any of that, but that's where we're seeing that push on our end. But farm and ranch is unique. These properties we're finding less and less of it, but we used to see where the property had been in the family for 150 years, and first time you're seeing something sold out of it. So it presents its own set of issues, and it helps to have an attorney to help your clients understand things that may pop up in these rural properties, such as easements, pipelines, leases, the effects of those, mineral rights, water rights, wind and solar. You've also going to have potentially, if you're talking possible turnkey operations where you're going to get equipment, whether it's irrigation, tractor, if it's a farm. We don't see as many farms these days, but if it's a farm, you're possible irrigation equipment, wells, pipes, water lines, tractors, implements, buggies. If you see more of the recreational, which we're seeing, which most of y'all will probably do one or more, you'll see potentially deer blinds, deer feeders, Polarises, Jeeps, pickups, tractors to mow the right-of-ways, that type of thing. You gotta have those in there and bill of sale. Anyway, it helps to have an attorney that can partner with your real estate partner, like you guys. I always encourage agents to find somebody in your area that you can work with if you need them, when you need them. You don't always need them, but and I'll be the first to admit we can get in the way sometimes, and I realize that, and we don't want to be in the way, but we also have a duty to protect our client just like you do. And so we have that attorney-client relationship once we establish it. So it's really important. So if you feel, especially if you're new to the farm and ranch area or non-residential, it'd be good to have an attorney involved at some point.
Well, and you know what? You kind of taught me. I'm going to carry on to that.
Sure.
You taught me that it's best not to wait until you have a signed contract and an escrow to call the attorney if there's a problem. Navigating with an attorney was new to me at one time, and John was very gracious, and he said, "Hey, listen, give them my information. Let me get to know them. If they're a buyer, before you guys, start getting out there and looking at property, let me introduce myself. So if there is an issue, they can come back to me. And, they don't have to put me on retainer. They don't have to hire me. But if I have a dialogue with them and they know me, then it's a lot easier than all of a sudden down the pipeline, oh crap, we have to turn this contract in less than 24 hours. John, can you zip through it real quick, right, so to speak? So I like to let my sellers and my buyers know, because of some of the coaching John has given me, introduce them to your attorney, or to searching for an attorney, and let them interview them just like they interviewed you as an agent, to get them familiar. So if they do need to reach out to that vendor for that service, it's not all hands on deck in a very short period of time. So that was something John taught me. So I like to, in my buyers and sellers interview process and in their welcome packets, I like to get that ball rolling. Like, hey, if we fill out a contract, we're going to need to write down who your attorney is for this sale. So, do you have one? Do we need to find you one? And that's a part of the real estate process, at least, in my business. So I wanted to just kudos, to John on kind of teaching me that service in that aspect. And just like John touched base, there are some items that we're not responsible for. However, we have to help our clients navigate those sources. We're responsible for the real property and the real estate. However, as y'all know, when you sell a ranch, there's a lot of other things out there, and needing a bill of sale, or needing other individuals to help navigate those services, like John had spoke about, water rights, surveys, hazardous materials. We see that a lot in the farm and ranch, the hunting industry, with CWD and anthrax. I know CWD was a hot topic for you, John, out there where you were. So really having somebody to help navigate those, especially if there's going to be some legal documentation written up on that.
You bet. Especially if you get into an area like that where you've got some potential hazardous whether it's CWD or other things, your attorney may want to, depends on the seller's attorney may want to draft up something that protects his client. Say, we've given you every disclosure, but we also want you to affirmatively agree that you're taking this property subject to the risks of CWD, things of that nature. We could run the gamut, but trying to get the best protection for your clients and having that seller's attorney on board early on, because they can help you get in front of those easements. And if you get an objection letter, they're ready to go already with trying to cure any title issues that may pop up. So that's it in a nutshell for that. So you want to move on to the contract, Lindsey?
Absolutely. I'm going to drop a link in the chat, which is going to be first and foremost the slides we just covered with John's information. If y'all want those, I put those in the public chat there. The presentation with just John's info and some of those highlights. And then also I'm going to put a copy of the contract, the presentation we're doing right now. It just came straight from TREC. And the most useful part of this is they actually redlined this for us so we can actually see these changes. So very excited to go through these. And like I said, we're covering the whole contract, so this will be a part 1, part 2 series. So hopefully we can hash out a lot of this today and then get to our next presentation. So go ahead, John. We're in your territory.
All right, good deal. Contracts, yay! It's such a fun subject to talk about. I'll try to keep it from being as boring as it is. On the TREC website, this form has been available since November. However, it's been voluntary use since then, but will go mandatory February 1st, 2023. So make sure on the end of the month, if you have these contracts saved in your forms or wherever your platform is, make sure you replace it with the new contract if you haven't already, because they will require you to use it. Yes, we have up in that link is this red line. It's very handy for me as a presenter. This is my first time to teach on it. And some of you have probably already taken some classes on it. I doubt I'm going to have much different to offer because it's really pretty straightforward, other than maybe my opinion on why they might have changed things. And that maybe what I can offer to bring to the table on it is some background on it, possibly. The thing I note, starting at page 1 is you'll notice in this version, if you've got it pulled up, everything in blue is what they've added. Of course, the red, maybe either is going to be what's been changed or struck. So at the very top, there's a notice right below farm and ranch contract says designed for use in sales of existing farms or ranches of any size, not for use in complex transactions. Well, I find that kind of interesting because the farm and ranch contract can be complex. It can be very straightforward. It can be as complex as you want to make it, really. Especially if it's an income producing property, you're going to have some more details to get into. Recreational, not quite as much generally. So I'm not real sure what they're talking about what a complex transaction means, but these contracts, as you all know, probably are very down the middle. They're fairly buyer friendly. I have seen and I have in my possession some contracts that might be considered more for complex transactions, but generally that kind of takes you guys out of the picture when it comes to drafting the contract if we need one of those. Certainly involved as far as the marketing and representing the client. I try not to. I always view my real estate agents and brokers as my partner in the deal because you know the client better than I do as far as the soft side of things, right? You've held their hand, gone to dinner with them, gone to lunch with them, shown the properties, or helped them market their property if they're the seller. My job is to help them get through this legally and as well covered as possible. So that being said, I'm not sure what a complex transaction is. I guess it's like what they say is you'll know it when you see it, huh? It's like
Absolutely. Well, and if we get to that point, I know you're there to help us, at least on our team. So, I want you, if you don't mind, I know we're covering some of the red lines, but if you have recommendations, for example, I know that, you advised me a few times that when you fill out the parties to the contract, using or assigns in that with the buyer or seller's information.
Yeah. So if generally you're going to see the buyer in that situation, that's where you'll see an and or assigns. It's on the buyer. The buyer's not sure if they're going to take the property in as an individual or if they're going to take it in the name of a corporation, or an LLC, or a limited partnership, some other entity other than their own names. You'll notice in these contracts, I don't believe there's any requirement for if there's an assigned, if it says John Dodson and or assigns buyer, there's no requirement in these contracts that the seller has to approve any assignment. So I caution you that as a buyer's, as a seller's listing agent, that you get in a situation where somebody's coming in as a straw purchaser. In other words, I come in, I've got maybe a high profile buyer, doesn't want anybody to know he's out looking for something. I'll put it in my name and we'll have an and or assigns. But I've also seen it where it puts a bad taste sometimes in the seller's mouth whenever all of a sudden they're like, hey, wait a minute, I dealt with you, John, and now you've assigned this contract to some big corporation or something, that was totally unexpected. So I caution folks when they see that, if you're representing the sellers, you might want to add in there or get your attorney to add in that an assignment of the contract will only be, will be reasonably granted, but only with seller's permission. Because if you have the unrestricted right to assign the contract, then now the seller is stuck with whoever's buying it. And that may not be as what they contemplated when they were going into the contract.
And also too, being able to explain that to your seller. I've had that situation to where, explaining this is what it means. And sometimes they're fine with that because it could be as simple as they're not sure if they're going to have that LLC paperwork ready to go at closing. And then also too, we've been on the buyer side where we had to have the or assigns because we were dealing with a celebrity purchaser. And sometimes there's a little discrimination there too. So, there's positives and, a little bit of negatives on either side. It's just very situational, but educating yourself on that and why it's used, whether you're using it or you're having to accept it and explain it to a buyer.
Yeah. So if you're representing the seller and you see that pop up on that offer, if you can try to make an inquiry on behalf of your client to the buyer's rep and say, hey, is this just, they're going to put it in, what's the deal? And it's very I see it fairly common is, it's just going into an LLC. They don't have it set up yet. That's what they intend to do. And they haven't decided on a name or can't come up with a name that's going to clear the, Secretary of State's, get approval through that. So, yeah. What else? Where else you want to go next, Lindsey? Property. Something important on property. You'll see there they've changed and allowed for or counties. They're adding that language to there in case you've got a property that lies on the county line. We had one the other day, Lindsey, we were looking at, it's in 2 counties. So I think that's just a little bit of cleanup on their part on the forms to add that. But here's what I'm going to tell you guys is, and I teach this in every contract class, is be sure if you can get a copy of the deed, if you're or I don't care if you're buyer or seller, whoever's filling that out, be sure and don't use a tax office parcel ID if you can help it. If that's all you got, okay. But you potentially run into not being able to have a valid legal description if somebody we're getting a bind on a contract, and then you don't want that contract to fail for challenging the legal description. So if we can get a survey and abstract number and number of acres, if you've got the field notes description, that's the best. And I try like heck to find that before I, putting it on a contract. I've seen it happen. I've had contracts challenged for that and they fail whenever the one party or the other wanted to get out of it. That was the first place they looked. So try to make sure you get if you can, get the preamble off the deed, which preamble is the short description on the deed. But the best, like I said, would be having that Exhibit A to it as well. Those are very important. And not an address on County Road 304 in Runnels County either. That's not going to be good enough to describe, because think of that. That land description needs to be as close to what the legal description is going to be on the deed. Now, if it's 20 acres out of 100 acres, say they've owned this property 1,000 acres, whatever it is, they've owned it for a long time. Grandpa Joe got it back in the 30s, and this is the first time we're selling a piece off, and you don't have the survey yet, I'm okay with that. If it's 50 acres out of, and you've got a good description of whatever it's coming out of, the 1,000 acres, whatever it is, and then put at the end of that, parentheses, to be surveyed. We can get by a lot better with that than we can with a tax ID number or just a guess. So very important. Looks like they've struck some language about water rights, strips and gores, easements, and other memberships, because that's going to be addressed further on down in the contract. Going on to B2, looks like they're allowing for multiple houses and garages, pretty minor change there. Sales price in 3. Looks like they just wanted to define things for you guys and make sure and try to take out any argument over what number needs to go there, to me, by defining exactly what cash portion means. So it's the money you're going to bring out of your buyer's going to bring out of pocket to closing, that they anticipate to put up or down, as down if they're financing.
Would you mind just giving us maybe an example and some descriptions? I know when they get to 3D, especially if you don't have a survey, I know this kind of scares some newer agents as to, well, what do we put in there? If the price is going to be adjusted based on the survey, and then also the caveat, if it's off 10%, either party can back out.
Right. And I just had one of those the other day. Broker got out of the deal because the survey was off, and it was a river property. And that's where you're going to run across it a lot of times. If it's an older property that hasn't been surveyed in a long time, or if it's on a river or a lake, well, not necessarily a lake, but you might see it more on the coast. Anywhere where there's moving water, you got a chance for avulsion or basically erosion or addition to the property. If the stream bed's cutting into your side, it's going to erode. If you're on the other side where it's depositing stuff, you could gain property. So just know your property whenever you're considering that. That's something that you're not going to see it on that piece out in Menard County or somewhere out in the majority of the country, in the state, really. It's just got a little creek bed in it or dry creek. You're not going to see that. So they've made some changes here because this is an issue that I've had discussions with parties over the years from sitting in the title chair, because they want the title company to sort out the argument. And I try not to get involved from the title side. Now, representing a client, obviously, have to have a good understanding so that we can explain it to them properly. So we talk about they've changed it from calculation to an adjustment, and it looks like they've added in here a blank. So you fill in the acres you think it is, if you don't have a good idea, or the acres that it is based on the evidence you have. Yeah, pretty straightforward there. I like that better than the way they had it before. But it is one that can be so I think the decision point for you as an agent would be, because it can cut both ways, right? Your seller could, if they're pushing for it, you know, they think it might be a little more, okay, great. But if it's a little less, well, then they're going to have they're going to make less money on it, right? And that's why they put that 10% in there. They don't want people thinking, they don't want people getting thinking, well, I'm going to get $1 million for it. Now it comes up 100 acres short, and now you're only going to get, you know, 850,000 for it. Well, that's more than 10%, way more than 10%. So
Obviously,
go ahead.
Oh no, I was going to say, obviously something just to keep in mind when you do have that scenario of buying or selling a large tract, you know, you're talking about thousands and thousands of acres where 10% actually could come up rather easily on a survey when you're looking at that multiplication. And then also, like John, you said, I didn't really think about the live water aspect of the property and, you know, the changes in that. So just being aware, and then obviously being able to explain it to your client as well. And these changes, this is really interesting. The sum of and of, you know, we're this is something that comes up quite a bit, and being very confident in what's going on and why it's here, because it may not apply, but if it does apply, you want to fill it out. You want to fill it out correctly in the best interest of your client.
Sure. So, you know, when you're on the listing side, that's where it comes in real handy to get as much information as you can from your seller, and, you know, at listing, and be very aware, because when it comes down to trying to know what to do in this situation as part of your negotiations, is knowing what you have in hand, and that just, whether they've got a survey or not, if they do, how old it is, how confident are they in it, has there been any fence line changes in the time they've owned it or previous. You know, all those little factors come into play when you're considering it, when you're dealing with this paragraph, and it can be a very, very sticky one if you don't have a good grasp of it, and don't take it for granted, I guess is my point, because I've had some agents come to me going, man, this thing's biting me in the butt. I said, well, I think you kind of, you know, I'm friends with most the ones that come to me like that, and I'm like, well, you know, you can't take it for granted. You got to be extremely careful with that one, and knowing your territory on either side of the ball, right? Like I said, it happens more in older properties that have live water, coastal areas, those type of places. So, all right, any questions on that?
Actually, we do have one question, and John, I just wanted to tab in here on Rancher's Title. The reason why my brokerage group loves using Rancher's Title is because we have the opportunity to do what's called a market ready title. So to get the property market ready, this first page here is super important when it comes to who are the parties, if I'm representing the listing, and then what the legal description is, like John had said. So being able to have a title company that will pull that and assist me, so I know that that information is going to be correct in page one, where a lot of the challenges are going to come from if you do get in trouble. At least in my experience, you want to have that legal description, and you want to know exactly who the legal parties are to rightfully sell this property, which you get, you know, from the deed, which he had said before. So just a little shout out to Rancher's Title on that.
Thank you.
Being able to do a market ready to get a lot of these answers ahead of time, like I said, in that seller's interview and seller's welcome packet. So that is, you know, we're used to doing it for a buyer. However, extensive research before you put a listing on the market is going to help you with success on that. So very, very happy to have you here. We're going to run down to leases, and obviously it cuts to 2 pages. So leases and the seller.
Yes. So if you've used the old form, there was these first 3, A, B, and C have been existing. Something of note in C is they have removed wind as a natural resource lease. And you'll see they've created in D the term for surface leases. And I agree with that, because legally speaking, wind and solar are yes, they are technically a natural resource. However, it's just those leases don't remove anything from your property. In other words, they burden your property, but they're not taking oil and gas out from underneath it. They're not taking any water out of your aquifer or your stream bed or your lake or pond. So they're not necessarily considered a natural resource when we think of it in those terms for leases. So they're addressing wind and solar in D, and they also give you the option here, which for me, I always kind of stressed my head when they added this in is, well, what if there aren't any leases? You don't have any place to just check the box of no leases, right? This assumes that there are leases in place. And, you know, we're supposed to check a box, right? Y'all are trained. Don't leave one unchecked, right? Well, I think they give you that option right here with, well, this one's just oral, but they still don't give you an option to say there are no leases written or oral that affect the property. So that's my comment on leases. That pretty short and sweet.
The one thing, John, and I know we'll get to this because I was surprised. This is asking information from the seller. Typically, when we write a contract, we write it from the buyer side.
Right.
However, you know, as representing the buyer, if we don't know this information, obviously the buyer's agent needs to be checking these boxes. So I find it very interesting that this new revision in contract has both agents and both clients inputting information in here on a very high level.
Yeah, so I think that's going to require you as buyer's rep to really drill down on this question. Among the many other things that you're trying to, you know, do your due diligence on when you're inquiring about the property on behalf of your buyer is when you get into these farm and ranches to drill down with that that seller's listing agent about, are there any leases, written or oral? Because, you know, if you're going to run across that property that's got, oh yeah, Jim Bob's got his cows out there, and you see evidence of grazing out there, and they don't belong to the seller. And sure enough, they don't have a written lease. They're going to have an oral lease. So they give you that opportunity to address that in two, because it's an oral lease, which is not, you know, it's not that uncommon to this day. So certainly more common, way more common 20, 30 years ago when I started doing all this, but people are getting a little more sophisticated, and you see written cattle leases, grazing leases now. But all right, moving on. What else? Oh, I see, while we're at it, Lindsey, I see a question about the survey adjustment surviving feasibility period if the survey is not completed until afterwards. Yes, that does survive your option period. So because that is very common for the survey to come in afterwards. And then once the survey comes in, title company has the right to update its commitment, which starts all your objection periods, which we're not quite to objections yet. So, but we'll address that when we get there.
We're coming up on it next.
Yeah. So we've got earnest money. Looks like they just decided to capitalize escrow agent in this whole thing. I'm not sure what that, somebody from title was in the room, I guess, on that contract and wanted to capitalize that. I'm not sure
I always think there's confusion because some people will actually put the name of their favorite escrow agent. I just put the title company in that section because obviously on the back end, you guys have several, escrow agents that will be assigned. And, you know, so I try to keep it as general as possible, more the title company than it is the actual agent I'm working with.
And I think they wanted to do that too. Yeah, I agree with how you do it because, yeah, you could get one of two in my shop, or three actually. And in larger companies, there's quite a few more. But obviously, if we've worked with you before and you like working with somebody, you just let us know. We'll assign that to that person. No problem. Hopefully, everybody's learned from the previous changes, you know, what the option fees, and is there any hiccups you have seen there, Lindsey, that we need to talk about? We have to.
One positive is that earnest money and option fee can be sent together to you. Before, it was a lot of agencies wanted two separate checks, or, they didn't want the check sent to the option check sent to title. And now this kind of cleans that up for delivery, especially when you're looking at that 3-day window. And then also just covering, I think it gets a little confusing on the days for some individuals, especially when we deal with holidays and Saturdays, and what's a legal holiday. So always talking to the title company, hey, just want to make sure my clients are out of town. Obviously now with technology, getting those wires in or those checks mailed, just on the service side with Ranchers Title. Obviously wiring is huge. Now there's apps where the client can take a picture of the check and title company can deposit it, as well as, I've seen with y'all in Ranchers and Garner, you'll send the client, if they want to send a check, which surprisingly a handful of people still send checks to. You guys will send them a mailing label immediately to where they can get that registered that it's en route. So, and you guys can receipt the contract. So I do like to be, mindful. I think more often than not on the residential side, we are seeing people that are not sending their checks in on time, and things of that nature, especially when they're buying a ranch, out of area. And there's, it's not uncommon. Some of these clients are not, they're on vacation, they're overseas. So I think best practices, because, that could be detrimental. It's something simple that could be super detrimental to the contract.
Yep. And we've tried, we recognize that early on, and we've tried to do our best to try to catch up with, we've always tried to implement as much of the conveniences that the residential market has driven, because there's so many conveniences for y'all in the residential world, whether it's apps, it's online access to everything. We've tried to incorporate that, but being mindful of, we recognize that there's still a lot of old school clients out there that, I still run across the ones that, especially it seems like in these farm and ranch deals where the client doesn't have an email. Every once in a while. So we can go everything from a mobile deposit into escrow for earnest money to, walking in with their old personal check, and hand delivered to us. So, and everything in between. But yes, back to your point, them putting the option fee together with escrow has made it so much better on us, and with clear direction on what we're supposed to do with it, from escrow officers to, send that option fee directly to the seller without further instruction from the buyer has been nice. So that's been a welcome addition to the contract from our standpoint.
Awesome. Yeah, me too. It's the clear as mud statement is it happens more often than not. So we are moving up in the farm and ranch world. So I think the next few lines are going to be pretty standard and straightforward. Obviously more so in farm and ranch, we don't have the set industry standards. We negotiate quite a bit of the price and who's responsible for paying for what. So title policy and survey, the buyer can pay, the seller can pay, or they can split it. We've seen that happen before. And then just going through here, one thing I know, John, I'll have you cover is that extra title insurance that could be asked for in shortages in area.
Right. I'll tell you right now. So she's talking about page 3, which is title policy and survey, the continuation of that. Little 6, and there's 2 boxes, 6I and 6II, 6.1 and 6.2. So that is what we call shortages in area coverage in title policy world, the title commitment world. We charge extra for that because what you're asking us to do is to delete that line from, where did I have it? Paid from Schedule B2, that we don't cover anything regarding hold on, I'm going to pull it up real quick so I don't tell you wrong. And basically, you're getting extra coverage for encroachments, improvements that overlap, roadways that might be there. But in order for us to grant that coverage, we have to have a very good survey. And typically we want a survey that shows all of the improvements, fence lines, wells, cabins, barns, houses, roadways that might be along the boundaries, pipeline easements and their locations, overhead electric line easements, anything that might affect the property, have some rights and others that affect the property. If the fences aren't on the boundary lines, we have to have a new survey that states that it is that it has located all the improvements, has located all the easements, and any other thing that might affect the property are shown on the survey, or they could not locate them because of vagueness if we've got some old easements or pipelines. But they also list all of our Schedule B exceptions on that plat. So we basically need a what they call a 1A survey whenever we get those, whenever you get that. So just know, if you check that box, you're committing to a much more detailed and lengthy involved survey than just a boundary survey that we typically see quite a few of. And a boundary survey is not going to cut it.
And that's something that's really common as representing the buyer, the seller's agent's like, oh yeah, we have a survey. But then when you look at it, you're like, okay, you have a survey, but it's a boundary survey and it's not going to suffice if we decide to request shortages in area. So knowing that going into it, if your client or the seller is willing to pay for a brand new survey or have it recertified. And also, too, I like to just reach out once again to my title company and say, hey, they've submitted this survey. We're looking at checking shortages in area for that additional title insurance. Will you accept this? And that's just something I normally go to John and I'll ask title if this is okay. And that way, because some of those surveys can be extremely expensive in the farm and ranch world.
Yes. Yes, they can be. So I really appreciate it when an agent reaches out to me as a title agent and says, hey, will this work ahead of time? Because they know it's a whole lot easier to explain it to the parties up front than it is. We get halfway, we get the commitment out, we get all this, we get all this work done. And then all of a sudden the survey gets presented to us, whether it's a new one coming or it's a recertification of the old one, but I haven't seen it until that point, and then they ask for coverage, and I have to deny it because it's not sufficient. Then they've got the decision. Then who's going to spend the money to do it, or are we going to just waive it? And let's try to avoid that, having that discussion on the backside. It's a lot better to have it up front.
Absolutely. Well, and you know what? We're going down to B, commitment. This was something that sometimes agents are a little surprised that within 20 days, hopefully the title company will get us a title commitment.
Right. We're required to do so by statute, by TDI rules, 20 days on acreage. I think we have 7 on residential or lot and block.
So best practices here. If you want more than a 21-day closing date, you better have a nice conversation with your title company.
Yes.
Beforehand, because we do have people that want to close, and I'm sure you've seen it pretty quickly.
I've been amazed at the amount of money people are willing to drop in a hurry on a piece of property without making sure that all the due diligence is done. For sure. If you want something sooner, we do our dead level best. Certainly, if it's within the counties that I have a plant in, which is Medina and Zavala and Uvalde County, I've got much more control over that. The other counties, I have to partner with a title agent in that county that gets me title evidence, and then we can get it back. But that's why we've tried to develop those relationships so that we don't get put at the bottom of the stack if we bring them a deal. We'd like to know, have that good relationship with those agents so that we can get it to y'all timely. In 21, I have to say that we've got so swamped that we didn't make that mark sometimes, admittedly, for various reasons, but that shouldn't be a problem. 22, we didn't have that issue just because we finally got back to a more workable pace that we could handle. Generally, we like to see, especially on if there's a lender involved, we sure like to see more than 20 days for a close on it, because just know the lender's probably going to take longer than that to get their appraisal and whatever else that they want for their underwriting requirements. But that reason that 20 days is in there because that's what we're required to do by TDI, Texas Department of Insurance.
Awesome. Well, the next section, the survey, to me is pretty self-explanatory. We run through it, with residential as well within so many days. If there is an existing survey, that T47 affidavit, and obviously 2 and 3, buyer or seller can pay, and then no survey. Obviously, John, you've seen places close without a survey.
Correct. Now, they may have, and it's usually when they've got, most of the time I've seen it without a survey. They've got an existing survey that everybody's happy with. Just know that title company, unless you're asking for that shortages in area coverage, if we've got a good enough field notes description, we're generally not going to require a survey. I know we get, in my experience, that's something that we get pushed on or leaned on, I guess, sometimes by agents is, are you going to require a survey? And that's my answer. Unless you want, if we've got a good enough legal description from the prior deed that satisfies the transaction that's contemplated, and we can legally define it and locate it, then we should have enough and we don't require a survey. The only time we will require a new one is, like I said, when you're asking for extra coverage. The surveys, I know, Lindsey, can be a point of quite a bit of point of negotiation sometimes. You and I and Kyla, my wife, who's owner in this with me, we've had those marketing discussions, right? Of you want to have if you're representing the seller, do you want to have a ready listing, not only the title work, but is it worth it to your client to invest in having that survey up front, and bake that into the asking price, if you want it, and it comes in pretty slick if you've got one. That's definitely one way to look at it.
Expedite getting to the closing table when all those questions are answered, right when they see the property to make an offer. Shorter option period, things like that.
I would think as a buyer, if you flopped out a brand new survey within the last 6 months and it's got everything on it that makes it look pretty nice to me as a buyer. If I'm going to drop a couple $1 million and boy, it shows where all the fences are and where everything is. I would think that would be appealing to me as a buyer. So, but that again, that's a marketing decision for y'all to decide in my book.
Well, I use it in my best practices. So we're going to go to my favorite section, 6D, the objection section.
Yes. It just like everything else in these contracts, the better you know them, the better you're going to be able to represent your client and explain things to them. I'm going to get kind of legal on you here. It's real important to know what 6A 1 through 5 are, that you can object to pretty much anything that's disclosed on Schedule B, except for those 5 things. Or actually 7 things when it comes down to it. And you cannot, but you also may object to any portion of the property lying in floodplain, V or A, but not X. And then, of course, any exceptions which present the following use or activity. So if you're concerned that your client's use may be jeopardized, or you're not sure if it's going to be prohibited, you need to put that in that blank right there. And I like to, when I'm representing a client, just say, I try to throw in as much global language as I can, residential, commercial, industrial, even if they're not going to do it. What if down the road that use might change? And then I always throw in, and I don't know that I can't prove that it's a best practice, but any other legal use contemplated by the parties, something like that at the end of it. Just know that blank for days is if you don't have an attorney yet, but all of a sudden you get this commitment that's got a whole lot of items on Schedule B, and your buyer goes, what is this? And you're going, well, this is a little more than I'm signed on for as the buyer's rep as an agent, which that's good. If you don't feel comfortable answering those questions, just know that you're now putting, if you have that buyer doesn't have an attorney yet, and now you call me and say, hey, John, we just got this commitment in. Can you represent my client? We're concerned we might need to object to a bunch of this stuff on Schedule B. Well, if you've got 3 days for me to object in that blank right there in little 2, and you got the commitment yesterday and you're talking to me today, now I've got to drop everything I'm doing and file a lengthy 2 or 3 page objection letter by tomorrow. You're putting me in a bind. I'll just tell you as a practical matter. So buyers, try to get as long a period of days for objection in there as you can, 7 to 10, and just know that you're dealing with property that could. I mean, I did one the other day that we got into we went from A to Z, we went from double A to double Z, we got into triple L, I think, is as far as we got. So that was 52, 70 Schedule B items. And a lot of them were able to, not all of them, but there were some that were able to clear it. And any buyer's attorney that's going to get that and object, he or she's got to go through every one of those, read every document, and make their objection. So it takes time. So give us as much time as you can. There is my plea to the group.
And I've seen on the seller's agent side saying, let's not give them a lot of time. And I look at it as, it takes both sides to work together. And if there is a cloud in that title, I'm sure the seller didn't know about it. And all we want to do is make the buyer and seller happy, close and move forward. So, it is on both of us, I think on both sides of the table, working together to get the things resolved so the clients are satisfied, because the last thing we want is, a year or 2 down the road, them to come back and sue us because we didn't give them time to make that sound decision. So I always like it. Collaboration is key. Awesome. I just want to let you know, one of our other managing brokers, Rick Carr, is here. He actually asked the question, what about leaving it blank?
Okay. Leaving blank, so before close date is used. Leaving the objection period blank, I believe.
Yes, and you know what? I've seen a lot of agents just leave it blank, maybe because they don't know what to do. What if you leave it blank? If you don't put any days in there, he said the paragraph reads earlier of closing date or number of days.
Yeah. So if you leave it blank, you've got until closing date. So, or what I would prefer, because I don't like blanks in contracts either, is put NA days. But I let me think about that, because that's a good point. I would leave it blank. Yep. That's even better. If we got until closing date to object, because what that does is then the buyer timely objects, which is on closing date in that scenario, then now we object. Now the seller has the time to cure, and say they get it partially cured and we issue another commitment. Well, guess what? If there's anything else that comes up in that deal, you start the objection period all over again in the cure period. So same for when the survey comes in. You're going to have some time to object to the survey once that comes in as well.
So if you're on the seller side, you want to see days in there. And I mean, I always like to put some days in there to give people direction, but great catch on that.
Yep.
Great catch.
Thank you. Yep. Okay.
Can you just touch base on exception documents for me real quick?
Yeah,
a lot of agents just pass right through that.
If you're the seller and you've got a lot of those documents up front that you can disclose to, which that rarely happens. One time it happens is if I've gotten in on the front end representing the seller, it comes to me and says, hey, we're gonna sell the ranch. We've hired Lindsey to be our broker. And they come to me and say, all right, let's get it ready. And I'll say, all right, well, let me see what I can get title wise out of it. and then we'll have exceptions ready to go up front, so you can present that to the buyer. So we kind of short circuit some of this objection period up front here, because now we've disclosed to the buyer these documents. But you better have a pretty good handle on it as far as what you're doing, because and if you agree to those, though, they're going to be permitted exceptions in the title policy and will not be a basis for objection to the title. So be very, very careful from the buyer's side in that you don't have a right to object when you sign that contract subject to those documents. So it's a catch-all. So my best practice for y'all is make sure it says none and move on. Right there. All right. Do you want to go on surface leases there?
Just to touch base, obviously talking about, this is also exception for those surface leases in the title policy. Could not be for objections to. I think, this is, when we're in those ranches that have a lot of paperwork, which obviously I hope you've been hired to review them, but just understanding, I guess, on the buyer side, you're limiting your objections.
Yeah, I mean, obviously, if you go out and look at a piece of property and it's got a wind tower or two onto or more, which is getting more common, there's going to be a surface lease and it's going to be part of the commitment, period, the end. Obviously, hopefully your buyer is going to get some, negotiate some royalties out of it, or some, continued damages moving forward. But I don't see that paragraph filled out very often either. It's rare. Everybody just waits till it comes out in a commitment, and then we get to the objection stuff on that and whether or not it applies, or if we're going to take it subject to it.
Absolutely. Well, we're going to finish up here on G with the title notices, and we will catch up on part 2 on number 7. So if you just want to walk us through.
Sure.
Through those basic notices.
Yep. Basic notices. Obviously you're advising the buyer to get a title policy on it, with a commitment. The statutory notice regarding in Chapter 49 in Texas Water Code. I don't know if any of y'all have seen any of those, but I see a few of them around. We have them in, I think we have one in Bexar County or Medina County, which is Hondo. Title companies should know that. We try to inquire from that, but the seller has a duty to deliver a notice, a statutory notice under Chapter 49 of the Texas Water Code regarding the tax rate. So if you've got a MUD or something that's charging or levying a tax, so when you get that tax statement, if you get a hold of it, or when you're looking at researching the property and you see the taxing entities in there, if you see one that has to do with water, you might have a duty as a seller to deliver that notice prior to closing, at or closing. Tidewaters, I don't see that one very much. I really can't speak to that, but I think y'all got a standard form that TREC has for addendums for those in the coastal areas. Annexation, I think they just throw that in to cover everybody right there. Again, dealing with water, chapter number 5, notices required there. Again, for public utility districts, chapter 5 involved. So number 7 is one I've never seen in 20 plus years of doing real estate law, is a Texas Agricultural Development District. So most everybody checks is not involved in there.
It's a no. The word on the street is that they thought about doing it. They put it in the TREC contracts, and then it never got done. And I was hoping to see this struck from the new contract, but it's still here. So
it's a placeholder in case it ever comes up. It'll be there, right? And they don't have to go back and amend the contracts. That's what they've done. So these are all very pretty self-explanatory. Just kind of be aware of them, and make sure you at least make yourself familiar whether or not these things might apply in your in the area where you are. So I think number 10 involves like a constant level lake.
And we've seen that more with the drought, of course, with some of these lakes and people thinking they own to the water.
Yeah. That's right. And then of course they've given you a new place to attach or give notices on these multiple municipal utility districts, water control improvement districts, or public improvement districts, which are PIDs. And there's notices required for each of those if your property is involved in that. So, all right.
Well, we're going to park it there. We finished right on the dot at 12. John, thank you so much. I want to let you guys know that we're going to cover part 2. We're going to start at property conditions and head on through the rest of this contract next week. We'll be broadcasting Friday at 11. If you do have any questions for me or for John, please feel free to reach out. I did put the initial, if you scroll up to the top, if you guys see that chat, hopefully you guys can all see that the chat that we had going. We have links to all the documentation and slides, as well as John's information there. So thank you so much again, John. I greatly appreciate you coming out and helping me with this as we all navigate these new changes.
You bet. I really enjoyed it. Thank you so much, Lindsey.
You're very welcome, John. You have a blessed day.
Y'all too.